Let's say you've got a seller. Let's say some offers are coming in, and one of the offers is closer to the seller's price than the other, but they're asking for inconsistent levels of buyer agent compensation. One's asking for 3%, one's asking for 1%. And let's say one of those buyers, you happen to know because maybe you saw him at open house, is probably in a protected class. I know you're not a lawyer, but you kind of probably should know what protected classes are. I mean, you had HUD training. I'm an attorney and a broker, by the way, so I've been to the HUD training when I got my license. And then let's say the other person, one of the agents is a protected class and one's not. And so now you've got inconsistent requests for buyer agent compensation and protected classes. Is that a fair scenario? And then secondly, so therefore, how can you help that seller sell a home without bringing an attorney into the matter? And if you can anticipate that, I don't understand how you can sell homes without an attorney on your team. I really don't. Now, let me bring it to another level. Are you aware that the DOJ said in the Massachusetts PIN case, no select v. Massachusetts PIN, that it said that buyers would be happy to know that their buyer agents were not being incentivized to have them pay more money for a home? I mean, I'm sure you can figure out what that means. Like in a multiple offer scenario, if a buyer has a buyer's agent suggests to their buyer to pay an extra $100,000 to be the winner, they get $3,000 more. So that would be an easy win for a disgruntled buyer after the fact, which in markets that are up and down or a little weak, a lot of buyers get cold feet even after they purchase the home. So do you recognize that risk? That would be called a risk of compromising the fiduciary duty of the buyer's agent. Wouldn't that be present in many home sales where you're allowing your seller to pay a percentage buyer agent compensation? I mean, how of the probably 200,000 sales this year where they were paying buyer agent compensation, that's an estimate. How many times do you think that buyer agent compensation was a percentage? Did anyone think of advising the seller that the DOJ told us this was a problem? Did anyone think of advising the seller that those risks could easily be mitigated with some forms or a little buyer intro and education? And so, I don't think there would be any risk to the seller to be protected. If you're paying full buyer agent compensation, I think you could have them jump through a simple hoop of saying, you're requesting this. We'd prefer to pay a flat fee. You're requesting a percentage. So we're going to start with a flat fee, but if it's very important to you, if you sign this waiver, you can turn into a percentage, something like that. So that's one risk. Now, there's two risks related to buyer agent compensation, but with respect to compromising the fiduciary duty of the buyer's agent, the other one's more complicated. We're not going to get into that. Now, the next one's steering. Do you see a steering risk in your forms and in your transaction? For instance, the buyer is being told, hey, don't worry, you can pay us 2.5% or 3%, but we'll get the seller to pay for it. We have the forms to do that. We check a box. The seller pays. Is that box really in the interest of the seller to even be there in the first place? Like, maybe you should be advising the sellers that these forms aren't really that good for you, Mr. Seller. I'm a realtor. These are the forms I have to work with them. But this box, it harms you. Shouldn't be there, really. If the realtor association is representing both sides, what's that box doing there? And I don't have any forms as a listing agent. I'm an attorney, so I do have forms. But as a listing agent, I don't have any forms to really properly counter that box. I can't mitigate the risks. And now we know that if you say no, like here's an offer, comes in close to your sale price. But if you say no to the buyer agent compensation, I'm going to advise you there's a chance that buyer is going to walk because that buyer might have been we know if it was a realtor and they showed your home to the buyer, they're in a contract for buyer agent compensation. So if you counter that to zero, they may have to walk. I mean, you're going to have to explain that as a smart listing agent. That's steering right there. Steering toward, the DOJ's told us, if you're steering towards a property for commissions or away from the property for commissions, that's steering built in. When you're opening your mouth and explaining basic, smart realtor stuff, you're basically explaining our process has steering built into it. That's what the DOJ said. It could be criminal. Are you advising your sellers on how to mitigate those risks? Now, here's another one. again, all when that buyer and that buyer's agents checked that G3 box, these risks they weren't the seller's problems before they hired a realtor, and the realtor have these forms where that box is checked. Before, they just asked you to sell their home. It was all good. You were going to do real order things. But now, with that box being checked, you've created landmines for the seller. So there's so much going on, but we'll just get to one more. We've got compromising the fiduciary duty, we discovered, steering, and what about like the commission fixing, the price fixing, keeping the process and the numbers high. Now, a buyer's agent's going to say, hey, I didn't realize when I was buying this home, I was paying for my own agent's commission. They said that in the class action suits. They've kept, and the sellers were keeping the price of houses high so they could pay my buyer agent. So I essentially was paying too much for the home. That's a risk. That's happening. We've got a buyer contracted almost all the time. We're seeing the buyer's agent saying 2.5 or 3%. That's a lot of money. That's potentially jacking up the price of the home. I was an econ major too. I understand money's fungible, but I'm saying, but because that's so obvious to you, if you get what I'm saying, then a little education for the buyer could be worthwhile. Like you could probably have them waive those risks once you gave them a little bit of education about money being fungible, but the sorts of the funds going into escrow to pay their agent. It's going to look like it's coming in from there. It could be the seller's money at that point. It could be the buyer's money, but it's really an escrow. We don't really know, but we're paying your buyer's agent as a convenience to you, and then we're going to ask you to waive these things that have been mentioned in the class action suits and maybe some other things. Again, if you're paying full buyer agent compensation, that should be done. That's what concierge level of service would be. Hey, if you're going to pay buyer agent compensation, let's make them sign these waivers and jump through these risks so you have very little or you substantially mitigated your risks of working with realtors and using our forms. You'd think that would be like part of the process of a concierge level service. They bring an attorney and say, hey, because you're working with me as an agent, I've been sued for these things. We've got risks. The DOJ's pointed it out, but I have an attorney to explain this to you and help you mitigate the risk. And in fact, if we do it right, we have some benefits because you know how we're talking about, one of the risks perhaps being offering inconsistent level of buyer agent compensation. We can turn that into a strength. We can leverage a consistent unilateral offer of buyer agent compensation, develop multiple offers to get more showings, to sell homes the way we used to before we got hammered. And in fact, it might even be an edge now because not everyone can broadcast buyer agent compensation or what was happening on the MLS. But if we do this right, we might position your home as exactly the home all these realtors want to sell in a slowing market. We could do all that if we're working with an attorney. That would be my fiduciary duty to explain all this to you. You can be proactive. If you're going to pay buyer agent compensation, which you're probably going to do with our process, which is passive, if you were to be proactive, have an attorney on your team, understand how to mitigate those risks, and use buyer agent compensation to bring in more showings, to get more agents working with buyers aware that you were going to pay buyer agent compensation and you're taking the risk away from them, you could get more offers. You're going to probably also, if you get really good, strong offers, you'll watch buyer agent compensation go away too as your price of your home goes up. But that's for another video. My name is John McConnon. Right now, we're coaching listing attorney. Well, we're coaching attorneys who refer clients to listing agents to protect their sellers. There's a lot more work. It's like a smorgasbord of, I don't even know if I said that right, of work for attorneys. If you just pick some of those boxes, I'd say as an attorney, you're entitled to $6,000 to $10,000 of the listing agent's commission. If you're doing all the work or you also choose the right form, you could be entitled to 50, 60, whatever percentage you really thought was fair for these transactions. Your sellers need to be counseled. Realtors can no longer do some of the work that still needs to be done. Attorneys step in, and attorneys should be getting paid at closing. And I've got a whole course from start to finish on that. But some of these individual courses like this one, the modules, would be interesting to professional agents and sellers as well. So I'm going to be bringing out more information at listingattorney.com. Thank you. I'm a broker and attorney in California. This was mainly because I can speak from experience about California law, but it's still a problem all over. Like this is a national issue. And there should be attorneys. Luckily, some states, there are attorneys on the team. But thank you. Listingattorney.com.